Well, good morning, everyone. My name is James Trainer, and I'm a partner in BDO's Sydney office. And welcome to our first webinar in the Working in Australia series. And we're turning it a little bit on its head for the first week. We're talking about working from anywhere. So welcome to you wherever you are. And certainly what we're seeing a little bit more these days, and what we'll talk about in the next hour, is the fact that many employees are no longer fixed to a particular office and might find themselves working anywhere around Australia or indeed anywhere around the globe. And so today we're going to touch on a few of the issues that arise in those sorts of circumstances. And joining me today are three experts in their field. We'll have Nadine Shaw first up to talk about some of the issues that arise for expatriate employees and the individuals when they're moving, both across jurisdictions as well as, domestically. Then Stefanie Merlino, a partner in our Melbourne office, will share with us some of the issues that arise for employers, and with a particular focus around payroll tax and workers' compensation. So these obligations that arise for employers where they've got employees working in different jurisdictions. And finally, we have Rebecca Thompson, who's a principal lawyer dealing in all matters immigration. And so a really important issue for not just the individuals to be across, but certainly for employers to be across when their employees come to them and ask the question, can I go and work in Bermuda? And we need to be mindful of the risks that are associated with that. Now, just before we get underway, just a couple of housekeeping matters for you. If you have any issues, please follow the link that's available there to the support for this webinar. Stefanie and I and Rebecca aren't really great at helping on the IT issues. We'll help you on your tax issues and your immigration issues, but there's some experts there that can help you. The presentation slides will be available as handouts, and they'll also be sent around at the end of the session. We'd love your questions. If you have any questions as we go through, please submit them using the chat function that's available there, and we'll certainly try and get to them as we go through the day. And if not, we'll endeavour to get back to you at the end of the session. After the session is concluded, you'll be sent an email containing a couple of things. There'll be a link to the recorded session, so you can go over it again and again at your leisure. You'll also get access to past and future webinars, and you'll have our contact details as well. So our three smiling faces of the presenters plus myself. And without further ado, as mentioned, we'll get through onto Nadine's session around expatriate employees. So over to you, Nadine.
Wonderful, thank you, James. So as you've probably seen, COVID has actually had a massive impact on the way employees are choosing to work these days. These are some of the more common trends that we're starting to see each and every day, and we certainly have noticed this amongst some of our clients. The growing number of short-term assignments, for example. So long-term assignments are not particularly attractive to employees anymore. Employees they don't necessarily want to be working away from home for too long. And short-term assignments can also be more beneficial to the employer, that helps cut costs for the employer ultimately. Employers are being forced to offer more attractive work experiences to attract and retain staff, and this includes having to offer a better work-life balance and certainly more flexibility. A common example that we have seen recently is where the employee is maybe sent to Australia for, say, 6 months and is allowed to stay in Australia for a few extra weeks to travel around Australia after their assignment. And this basically gives the employee a little bit more flexibility and certainly makes the assignments a little more attractive for the employee. Another trend that we see is remote working arrangements. Employees now realize that it's not necessary to work in a particular location, and employees' expectations certainly have changed. Take the Great Resignation, for example, that happened earlier this year, where more and more employees found themselves changing jobs or dropping out of the workforce altogether because the job didn't necessarily fit their expectations anymore. So employees are choosing and some even demanding to work from pretty much anywhere. And again, employers are compelled to offer flexibility and are having to adapt to remote working arrangements to keep the employees happy. A very common example that we see in the workplace every day is where the employee might return home to be with their family, but they continue to do the work that they were doing previously in the other country. And lastly, another common trend that we have is skilled migration, where employees are being moved to the job. More and more employers are starting to employ employees interstate and overseas and getting skilled labor from those jurisdictions. And particularly now, with border restrictions no longer being an issue, we've already started to see a rapid increase in the amount of expatriate assignments. You probably are aware that just recently the federal government announced its decision to raise the skilled migrant cap, and this alone will result in a massive influx of overseas skilled workers coming to Australia very soon. Okay, so what does this mean from an expat tax perspective? Where you employ an overseas worker to work in Australia, or if you send an employee to work overseas, there will almost always be tax consequences that you need to consider in either the home location or the host country or both. So these are the following things to be mindful of. Firstly, the employee's tax residency status. Now, broadly, an inbound employee who comes to work in Australia has an intention to be in Australia for longer than 6 months will likely trigger Australian tax residency. For someone who is outbound, actually leaving Australia to go overseas to work, breaking their Australian tax residency is a little harder, and actually requires that the employee establish a fixed home in that overseas country for at least 2 years, and also they have to demonstrate that they've broken ties with Australia. Now, breaking ties with Australia could be, for example, taking the employee's family along with them on assignments, renting out or giving up their Australian home, potentially closing Australian bank accounts, or at least notifying the Australian Electoral Commission that they are planning to depart Australia. And the main reason it's important for the employee to be aware of his or her Australian tax residency position is because it ultimately determines the scope of liability for the employee, and then also the knock-on effects for the employer and what the employer's obligation will be. So just in terms of the employee's scope of liability, very broadly, an inbound employee who enters Australia on a temporary visa and triggers Australian tax residency will be considered a temporary residence. And a temporary residence is taxable on worldwide employment income, but only Australian-sourced passive investment income. And someone who is also inbound, but who holds not a temporary visa, but say a permanent visa, or who has a spouse who is either an Australian resident or holds a permanent residency visa, will be considered a residence as opposed to a temporary residence, and they'll be taxable on worldwide income. Someone who is a non-resident will only be taxable on Australian-sourced income. Moving on to the next slide, you should consider potential permanent establishment risk. You must be particularly careful when you do allow remote working arrangements. I've seen a lot of instances or a lot of examples where employees or employers allow their employees to work in any country doing the same work that they were doing initially. Pardon me. As an example, let's say an Australian national who might move to the UK, take up employment with the UK company, and after a couple of years, they decide to return to Australia for family reasons, but they continue to work. They continue to work in Australia doing the UK work that they were initially doing, and depending on the work arrangement and depending on that particular employee's responsibilities and duties, just be mindful that there could potentially be permanent establishment. It could create a permanent establishment for the company in Australia, and that's creating a tax presence for the company in Australia. Vice versa, for an Australian company who allows an employee to work remotely in another country, but they continue to do their Australian work in that other country, could potentially give rise to a permanent establishment for the Australian company in that other country. So be particularly careful when allowing your employees to work remotely. Something else to consider is your employer tax obligations. As I mentioned to you earlier, depending on the employee's tax residency status, it could have a knock-on effect for the employer. So generally, where an employer has an employee working in Australia, this will more likely than not create employer tax obligations for you as the employer. And these obligations can include pay-as-you-go withholding, super, fringe benefits tax, payroll tax, and workers' compensation. And my colleague Steph will chat a bit more about that in more detail later on. But just be very mindful that if you are non-compliant, severe penalties can be incurred. And just as an example, for superannuation non-compliance, the ATO can actually render really severe penalties of up to 200%. So just be very careful with that. On the next slide, fringe benefits tax. Majority of overseas countries, they don't have FBT. They don't know what FBT is. In those other countries, they typically tax fringe benefits as part of the employee's salary income, and they process it through payroll. However, as most of you will know, in Australia, we have FBT. It's an employer obligation, and it's actually a separate reporting altogether. So a lot of companies are not aware of this. So if you do have any inbound employees from your overseas entity, and your overseas entity is not registered for taxes, the local entity, we've seen in practice that in certain instances, the local entity can actually report on behalf of the overseas employer. So just be mindful if you do have employees coming in that you might actually have to report on behalf of your overseas entity for FBT purposes. Superannuation is also something that you should consider. For inbound employees on a temporary visa, there are certain exemptions, I beg your pardon, that can apply when you have an inbound employee on a temporary visa. And as long as they have a certificate of coverage in place, if there's a bilateral agreement between Australia and that employee's home country, you can actually, you as the employer can be exempt from superannuation. It's very important that if you're not going to contribute to super, that you keep that certificate of coverage on file, so that should the ATO ever come knocking on your door, at least you can produce the certificate of coverage to indicate why you haven't contributed to super. Another exemption that can apply for super purposes is the senior executive exemption. However, that there are a bunch of other criteria that needs to be met in order for you to be able to apply this exemption. And next, your other country considerations. Be sure to always check what the tax obligations are in either the home or the host country or the other country that you send your employee to or that they're coming from. We've seen many instances where the employer is not aware of what the tax implications might be. And actually, some of them actually might not even think that they have obligations because they're sending the employee to another country. It's a very short period of time. The contract hasn't changed. They're still paying the employee per usual. And so there's really not much of a change except that the employee is working in a different location. So a lot of employers don't think that there's any other tax consequences to consider, but be very careful. Because we find a lot of employers that don't actually think about these consequences find themselves being non-compliant, and then having to seek remediation after the fact. On the next slide, we have double tax treaties. And Australia has a number of double tax treaties with a number of other countries, and treaty exemption may be available in some instances where the employee does not work in a particular country for more than 183 days. However, this should be considered with massive caution, as there are very strict requirements that can apply. Many countries actually apply the economic employer approach, where very broadly, this looks at the overall substance of the relationship between the employer and the employee to determine who the actual economic employer is. And this includes looking at factors such as who has control over the employee's duties, who the employee reports to, which entity bears the risk, etc. Those type of factors. And at the end of the day, once you've assessed those factors, and if it's found that the Australian entity is the economic employer, then more likely than not, treaty exemption will not apply. So I just caution to be very, very careful when you are considering applying the treaty, and particularly when you have assignments of less than 6 months. The next thing to consider is tax equalization. Many companies have global policies in place to protect their employees from any tax disadvantages because they're sending the employee on assignment. And essentially, tax equalization ensures that the employee continues to pay the same amount of tax as if he or she had remained at home. Tax equalization policies are more suited to long-term assignments. And so, as I mentioned earlier, with fewer long-term assignments occurring these days, employers are now forced to rethink their policies. And also, we've also seen in practice, a lot of the times, employers are less likely to tax equalize their employees, where it's by choice that the employee chooses to work in a different location. Moving on, global policies. As I mentioned earlier, employers are being a lot more flexible these days, and they're promoting policies which allow employees to work from pretty much anywhere for 3 to 6 months at a time. And we're starting to see this trend a lot more these days. And whilst this does sound like a great idea, there's a fair bit of work that should be done behind the scenes beforehand, just to ensure that you're not triggering or creating tax obligations just because the employee is choosing to work from their home. Therefore, it's important for the employers to refresh and revisit their global policies. But also, more importantly, these arrangements should be considered on a case-by-case basis, rather than just rolling out your policy and then forgetting about it altogether. Something else to consider is your single touch payroll, and this is particular for outbounds that we've seen a lot, where, say, for example, an employee is outbound, they go and work overseas, but they continue to be paid by the Australian entity. We recommend that you actually seek advice in instances like this, because a lot of employers might think that just because they're continuing to pay the employee, that they have to continue to pay their payroll through payroll, they have to continue withholding pay-as-you-go, and they have to continue contributing to super. This may not necessarily be the case, and it's all dependent on, again, as I mentioned earlier, on the employee's tax residency status. And if this actually isn't addressed properly, this can cause complexity for the employee at year end when they lodge their tax returns. Therefore, we recommend that if you do have any employees that you do intend to send overseas for long periods of time or even short periods of time, and you continue to pay them, ask the questions as to whether or not you have to continue payroll and continue super. And then just lastly, sorry, I'm just conscious of time. So the takeaways is just to plan ahead. We've seen over and over that employers tend to allow their employees to work remotely, or they send them to different locations, and they're not necessarily aware of what the implications might be. So they find themselves having to seek remediation, having to mitigate penalties after the fact. So this can be a very timely and costly effect for you. So most importantly, plan ahead. And if any of this has so far raised any red flags for you, or if you have any questions on any of the above, or if you're aware that you haven't been compliant to date, we recommend that you do a voluntary disclosure to the relevant tax authorities. It's always easier to mitigate penalties if you are forthcoming about your non-compliance before the tax authorities pick it up and commence any investigations. So if you need any assistance with the above, or if you need any assistance with any voluntary disclosure, we're more than happy to assist with this. And with that said, I think I will hand over to Steph for the employment tax obligations.
Thank you, Nadine, and good morning, everyone. It is great being able to discuss with you some of the employment tax challenges faced by organisations as a result of employees working from anywhere. As James and Nadine have discussed, we are seeing a shift in the way employers and employees work off the back of the COVID-19 pandemic. Prior to the pandemic, it was not uncommon for employers to expect employees to work exclusively from the office. In addition, many employers just didn't have the IT infrastructure to allow remote working. Fast forward to post-pandemic, and employees working 5 days a week in the office is now increasingly uncommon. We are seeing hybrid working arrangements. I know that's what BDO has as well, which consists of a number of days in the office each week and a number of days from home. We are seeing cross-jurisdictional working. However, this creates complexities when it comes to determining and complying with state-based obligations, particularly payroll tax and work cover. So to begin with, payroll tax, a state-based obligation, a tax that is imposed on taxable wages in the jurisdictions in which an employer employs and in which the employee performs services. It is a monthly obligation, and an employer is typically required to lodge monthly returns between July and May of the following year, with an annual reconciliation to be lodged in June. If an employee works wholly in Victoria, for example, during a calendar month, then an employer has payroll tax obligations in Victoria during that calendar month. However, complexities arise when an employee performs services in 2 or more jurisdictions in a month. There are Nexus provisions that apply in these circumstances, and they consist of a 4-tiered test in order to determine the jurisdiction in which an employer has payroll tax obligations. It's important to note, given payroll tax is a state-based obligation, these provisions are harmonised across each jurisdiction, and there's a consistent revenue ruling in each state and territory. So if we move on to the next slide and the 4-tiered test under the Nexus provisions. The first test looks at an employee's principal place of residence, also known as their PPR, during that calendar month. If the employee has more than one PPR, then it looks at the employee's PPR on the last day of the month and deems that to be the PPR for that whole month. Now, this is a sequence test. So if the Nexus provision, so if that first test isn't applicable, then we move to the second test, which looks at an employer's ABN address or principal place of business, PPB, during that month. Again, if the employer has more than one PPB, then it looks at the employer's PPB on the last day of the month and deems that to be the PPB for that whole month. If both the first and second tests do not apply, and this might be where an inbound employee coming into Australia, with the employer also being overseas and without Australian premises or an ABN, then we look at the third test, which is the jurisdiction in which wages are paid or payable. And then lastly, the fourth test considers the jurisdiction where services are mainly performed. And mainly performed means more than 50%. Now, working through our first example, John Smith works for ABC Proprietary Limited. John resides in Albury, New South Wales. ABC Proprietary Limited has one office located in a different state, that's right on the border, Wodonga, Victoria. Up until the pandemic, John worked exclusively from the office in Victoria. Post-pandemic, ABC Proprietary Limited has a hybrid working arrangement and allows employees to work up to 2 days from home. So in this instance, John works 2 days, or up to 2 days, in his home office in Albury, New South Wales. What does this mean from a payroll tax perspective? Well, firstly, the Nexus provisions apply because in any given month, he is working in 2 Australian jurisdictions. we look at test 1, which looks at his PPR is New South Wales. As a result, ABC Proprietary Limited is required to register and pay payroll tax in New South Wales. An interesting outcome, because ABC Proprietary Limited only has one office in Victoria. So the Nexus Provisions really demonstrate that isn't the only test to consider, and as a result, in this circumstance, ABC Proprietary Limited has obligations in jurisdictions outside of the jurisdiction that they have their business operations. Moving on to the next slide and a second example. Taylor Tax works for DEF Proprietary Limited in Wodonga, Victoria. Taylor works exclusively from the office. Taylor resides in Albury, New South Wales. Her employer DEF has offices located in all Australian jurisdictions. In September, Taylor worked for 1 week, then took 3 weeks of leave and travelled to Italy, the lucky thing. Taylor planned to stay in Italy for an extra 2 weeks in October and worked remotely during that time. When travelling home, Taylor stopped over in Queensland for 1 week and worked from DEF's Brisbane office. Taylor arrived home in the last week of October and returned to working in the office. So we've got 2 months that we need to separately consider, given the fact payroll tax is a monthly obligation. So if we first look at September, where Taylor is working for 1 week in the office in Victoria, quite clear cut, the payroll tax liability exists for DEF in Victoria. In October, however, services are performed partly overseas and also in Queensland and in Victoria. If we look at test 1, given that's the first test that we need to consider, and that is Taylor's PPR. Taylor's PPR is in New South Wales. As a result, DEF has a payroll tax liability in New South Wales, even though no services were actually performed by the employee in New South Wales at any stage during that month. So this is absolutely another interesting outcome. So if we move on to the next slide and overseas employment, there is an exemption that applies to services that are performed in an overseas country for a continuous period of more than 6 months. For overseas employment less than 6 months, the exemption does not apply, and instead wages will be taxable in full in the applicable Australian jurisdiction. Now, a really important note is, unlike income tax, there is no apportionment of wages for payroll tax purposes. Wages are aggregated and fully taxable in the applicable jurisdiction. So if we think about it, a common example, and that is a circumstance where an employee is paid a bonus in June, and that bonus relates to the employee's performance across the whole financial year. Only services performed in June, being the month of payment of the bonus, will be taken into account to determine the jurisdiction in which wages are taxable. In addition, the total bonus amount will be taxable in June. And then another important point relevant for those employers that have employee share schemes in place. Payroll tax obligations apply on the relevant date, being either the grant date or the vest date. The Nexus provisions also apply to ESS interests, so those 4 tests that we've discussed. And these provisions are applicable where an employee is working in 2 or more jurisdictions during the calendar month that an ESS interest is granted or vests. Now moving on to work cover, another state-based obligation. Essentially, work cover is an insurance that employers are required to maintain in the jurisdictions in which they employ, in the event an employee has a workplace accident or injury. Unlike payroll tax, work cover is an annual obligation. So you do need to provide an estimate of rateable remuneration in advance of the financial year, and then at the end of the financial year, you submit your actual rateable remuneration. But the good news, it's not a monthly ongoing obligation throughout the year that you need to complete or you need to file, noting that you may have obligations throughout the year to work with the regulators and adjust your remuneration, and we'll come to that once we talk about the specific data connection provisions. Challenges arise when an employee works in 2 or more jurisdictions. so where a worker doesn't have a fixed place of employment, or where the jurisdiction in which a worker resides is not the same as the jurisdiction in which they work. To overcome some of these challenges, I mentioned the state of connection provisions. These have been enacted across the various jurisdictions. These provisions provide that workers are to be insured in the jurisdiction to which they are connected. Care should be taken when considering these provisions, as unlike payroll tax, work cover is not harmonised, so there are some differences in the various legislative provisions for each jurisdiction. Now, this next slide sets out the 5 tests that make up the state of connection tests. Now, these come from Victoria. They are typically similar across most Australian states and territories. Now, if we move on to the next slide and work through test 1, the usually works test. If a worker usually works in one state, then that state will be the applicable jurisdiction that the worker is connected. Consideration is given to a worker's work history with the employer over the preceding 12 months. Test 2 looks at where the worker is usually based. So if test 1 doesn't identify the applicable jurisdiction, we then consider this usually based test. If a worker is usually based in one state, then that is a state that is the applicable jurisdiction to which they're connected, and the employer must consider the period that the worker works in a state during their employment, together with a range of other factors, which include any place included in the employment contract and any place provided by the employer where equipment or materials for employment are stored. The third test looks at business management or control. We look at this test if tests 1 and 2 don't identify the applicable jurisdiction. If there is a principal place in Australia where the employer's business activities are managed or controlled, then that will be the applicable jurisdiction that the worker is connected. And there are a number of factors that should be considered as part of this test. That includes any place that the employer's officers direct, control and coordinate business activities, or any place held out as the head office, and ASIC or ABN records. Now, test 4, this is only applicable for workers who work on a ship. This is the ship worker test. The applicable jurisdiction is the state in which the ship is registered, or in the event that the ship is registered in more than one Australian jurisdiction, it looks at the jurisdiction that they have most recently become registered. Test number 5 is the place of injury test. So if tests 1 to 4 are not applicable, then an employer must consider test 5, which provides that the applicable jurisdiction is the state or territory that the worker is in when a workplace accident or injury occurs. Test 5 is not relevant if there is a place outside of Australia where a worker may be entitled to compensation for the same matter. And this is to essentially ensure that the worker does not double dip or is not compensated twice for the same injury. The cross-border provisions allow a worker to work temporarily for the same employer under the same contract of employment outside of their state of connection for up to 6 months. However, where a worker works out of their state of connection for more than 6 months, an employer must review their work cover arrangements in relation to that worker. If they determine that the arrangements remain temporary, no change is required to their state of connection, or alternatively, there may now be these arrangements may be permanent, in which case the worker has a new state of connection. And this is an example where the employer should then work with the insurer to ensure that they adjust the disclosure or the rateable remuneration disclosures for that worker, and they've been correctly included in the applicable state to which the worker is now connected. So we've now worked through the respective tests for payroll tax and work cover, and it's quite clear that they do not contemplate some of the challenges that businesses are now faced with given today's decentralised workforce, given remote and cross-jurisdictional working. If we look at the payroll tax Nexus Provisions, these were last amended in around 2009, so 13 years ago. And the state of connection tests for work cover purposes were also introduced prior to the COVID-19 pandemic. A key challenge with these provisions is the differing tests for each obligation and the potential for a different outcome for payroll tax and work cover purposes. And as an example, if we revisit our scenario relating to John from Albury, New South Wales, where he worked 2 days per week from home and 3 days from his employer's office in Wodonga. In this instance, a payroll tax obligation exists in New South Wales as a result of test 1, and that's given his PPR is in New South Wales. Whereas from a work cover perspective, obligations exist in Victoria as a result of test 3 being his employer's business operations. So that in itself, this example highlights the complexities with these different regimes. The likelihood of 100% compliance with these provisions is inevitably challenging. So you might be wondering what the risk is in the event of an incorrect disclosure of wages of remuneration. Firstly, there's a financial risk of understated taxable wages for payroll tax purposes or understated insurance premium for work cover purposes. In addition, from a work cover perspective, there is a reputational risk in the event a worker is not insured in the correct jurisdiction and therefore is not entitled to compensation in the event of a workplace accident or injury. However, we absolutely recognise that there are a number of uncertainties in this space. First uncertainty, audit activity, and how high is the risk of detection? Whilst we know that payroll tax is very highly audited, the revenue authorities have an approach nowadays of targeted auditing. This particular issue around the Nexus provisions remains an uncertainty, particularly given some of these challenges are more prevalent in a post-pandemic world. What about sharing of information between the regulators? We are aware that the regulators share information. However, it remains unclear how information will be shared in the context of these provisions. And then future amendment of the Nexus provisions and even the state of connection provisions. Given these provisions were implemented prior to modern working arrangements where an employee can effectively work anywhere, it's unclear whether these provisions will be simplified. Despite these uncertainties, however, we strongly encourage that organisations consider what processes and procedures need to be implemented in order to comply with these obligations. And I think the key process is being able to monitor and record an employee's work locations. So where are they working at any given point? So I think it's fair to say, watch this space, and I have no doubt that we'll be seeing more to come. And moving on to immigration, I'll now hand over to my colleague, Rebecca. Thank you, Rebecca.
Good morning, I'm Rebecca Thompson, Principal Lawyer at BDO Migration Services. So as we know, there's currently a global war for talent. We've seen the recent announcements by the Australian government, which acknowledge the critical role of skilled migration in resolving the current skills and labour shortage crisis. Globally, we know that employers are struggling to meet their skilled workforce needs, and governments are playing catch up with immigration settings. So in this increasingly connected world, with surging demand for skilled workers, new ways of working must be considered. The COVID-19 pandemic has accelerated the shift toward remote working. More and more businesses are relying on an increasingly mobile workforce to succeed in today's global economy. And many businesses are endeavouring to build teams that offer the best functional expertise from around the world, regardless of geographical location. Without an increased acceptance of borderless work, businesses may have difficulties competing in the current environment. And to the next slide, please. There are obviously challenges between what employers may wish to offer, what employees may want, and what is achievable in an increasingly regulated global environment. As of August 2021, 41% of all employed Australians regularly work from home, up from 32% in August 2019. In 2022, over 1 million Australians are currently living and working overseas. And this forms part of the 281 million international migrants globally, the largest number on record. According to global research company Gartner, 65% of workers are considering the role that work plays in their lives post-pandemic. 73% of professionals consider their location of work to be essential to job satisfaction. So these findings indicate that we are at the start of a work anywhere revolution. The Australian Bureau of Statistics has reported a 47% increase in job openings in Australia over the past year and a 16% increase in turnover, meaning the current job market is an employee market. In this environment, companies must consider how they can attract candidates, and employers who are willing to embrace the work anywhere model may in fact be ahead of the pack. In the near future, more companies will adopt a borderless model so that they can attract and retain the very best candidates. Next slide, please. Australia has one of the most highly regulated immigration systems in the world. The Migration Act and regulations alone are over 2,000 pages. The frequent changes and complexity make it a minefield, which is difficult for many individuals and businesses to navigate. As such, this is a brief summary and does not replace specific advice which should be obtained whenever an individual is considering travelling to Australia to work or an employer is considering employing a foreign worker in Australia. Under the Australian Employer Sanctions Framework, employers are liable and can face both civil and criminal penalties if they employ a visa holder in breach of a work condition, whether knowingly or not. The Department of Home Affairs penalties for a breach are significant, and as such, individuals and employers need to understand which visa conditions apply to each visa and what work is permitted and when. Next slide, please. The Visitor Visa program allows travellers to enter or remain in Australia for short-term visits. Oh, sorry. If you could go to the, thank you. The Visitor Visa program allows travellers to enter or remain in Australia for short-term visits. The program can be divided into two main groups by travel purpose. That's the tourism or business streams. Tourism activities include holiday or recreation, for example, taking a cruise or visiting family and friends. Business visitor activities include making general business or employment inquiries, investigating, negotiating, entering into or reviewing business contracts, conducting activities as a part of an official government visit, taking part in conferences or trade fairs or seminars, but not being paid to take part. Visitor visa holders cannot perform a work activity in Australia that would normally receive a payment, as these visas are granted subject to condition 8101, and that is the holder of this visa must not engage in work in Australia. However, allowances are made by the department where in certain circumstances visitor visa holders can work for an overseas employer during their period of work in Australia. Departmental policy allows those wishing to work online, for example, a stockbroker wanting to check emails, share prices, etc. online, to apply for a tourist stream visa if the online work is incidental to a holiday. Where an individual is holidaying in Australia for a short period and just wishes to keep on top of work back home, again, that is the work is incidental to their trip, they are actually not breaching the no work condition. Where an individual wishes to continue their overseas work, basically on a full-time basis, there may be significant concerns. But generally, departmental policy specifies that where there is no risk that an individual is taking a job away from an Australian, such work can be considered on a case-by-case basis. So for those wanting to travel to Australia for a holiday, so long as the online work undertaken is for an organisation operating entirely out of Australia without even a local branch office, and the work is considered to be not taking a job away from an Australian, then an individual may be able to do so on a visitor visa. Go to the next slide on working holidays. The working holiday visa and the work and holiday visa allow eligible passport holders, who are usually aged between 18 and 30, but up to 35 for some countries, to have an extended holiday in Australia while working to help fund their trip. These visas are granted subject to condition 8547, which is a limitation designed to restrict the visa holders so that they cannot work for the same employer for longer than 6 months. However, departmental policy specifies that working holiday makers may work for the same employer in Australia for more than 6 months without requesting permission if the work is in different locations and work in any one location does not exceed 6 months. Departmental policy also makes clear that the employment limitation applies only to businesses operating in Australia. That is, where the visa holder is working for a business operating outside of Australia, the work limitation does not generally apply. It's relevant to note that to support Australian businesses during the pandemic, the government has temporarily relaxed the 6-month work limitation. Whilst this relaxation is due to end on the 31st of December, the department has advised that this is under review and it may be extended to assist in meeting labour shortages during this period of record low unemployment. I'll go to the next slide. The Subclass 400 visa allows individuals to travel to Australia to do short-term, highly specialised, non-ongoing work. Generally, the stay period allowed is up to 3 months, but up to 6 months is available if supported by a strong business case. This visa generally has shorter processing times, which can assist employers who need foreign workers to enter Australia relatively quickly to undertake work. However, the work must be specialised and not be able to be filled from the local workers market. There are also salary and related considerations which must be met. Unlike the Subclass 482 visa, which I'll touch on briefly shortly, this visa is applied for individually and it is not an employer-sponsored visa. However, individuals must evidence that they have support from an Australian organisation. All applications for Subclass 400 visas are assessed individually and additional requirements may apply for certain passport holders. The amount of information and documents required can vary greatly depending on the circumstances of the individual. On to the next slide. The Subclass 482 visa and its regional equivalent, the 494 visa, are the visas most commonly used by businesses who are seeking to overcome local labour shortages. These visas are temporary residence visas that allow businesses to sponsor overseas workers to undertake work in Australia for a period of either up to 2 or 4 years, depending on the type of work they'll be performing and their passport country. The visa is granted subject to condition 8607. This condition means that the visa holder cannot cease employment with the sponsor for more than 60 consecutive days. Work must be generally undertaken on a full-time basis, except in limited circumstances. And primary visa holders cannot undertake secondary work or work for themselves, and they cannot change their employer or occupation without first obtaining approval from the Department of Home Affairs. Visa holders who are nominated in certain exempt occupations may work as independent contractors of the sponsor or could work for multiple different employers who may not be their sponsor. All visa holders are required to maintain health insurance whilst they're in Australia, but any accompanying family members have unrestricted work and study rights whilst in Australia. It's important to remember that the department has the ability to monitor visa holders' compliance with visa conditions through information obtained through both employers, health insurers, and other authorities. And there are extensive requirements which must be met by both employers and applicants to be granted this visa. Employers are required to lodge a separate nomination application which evidences that the labour market testing, salary requirements and genuine position requirements are met. Individuals must lodge a separate application evidencing that they meet the requirements for the grant of the visa. This visa is subject to extensive employer obligations as well as individual visa conditions. On to the next slide. As discussed and mentioned by both Stefanie and Nadine, Australia is a highly regulated jurisdiction and the government has an unprecedented commitment to protecting and managing Australia's borders whilst endeavouring to meet Australia's economic needs. The Department of Home Affairs has continued to undertake reforms in border processing, biometric systems, the building of new capabilities for visa and citizenship processing in order to deliver better regulatory compliance and improved risk identification and management. But the department does continue to advance its digital processing to better allow for an integrated approach and the sharing of data and predictive analytics. Data matching is increasingly used by the Commonwealth and state agencies to effectively detect and deal with compliance risks. The sharing of information and data across government agencies is part of a whole of government approach, which employs sophisticated risk assessments with the aim of delivering compliance and enforcement outcomes. The ATO collects information directly from the Department of Home Affairs on active and newly granted visas. The data is matched against ATO records to ensure visa holders, visa sponsors and migration agents and lawyers are meeting their tax and superannuation obligations. Visa data is made available to the ATO compliance staff to support ATO risk profiling and trend analysis of the visa population. In the 2022-23 financial years, the data collected from the ATO by Home Affairs includes address and contact history for visa applicants and sponsors, all visa grants and visa grant status by point in time, all international travel movements undertaken by visa holders, including arrivals and departures, and full sponsor details. The number of individuals affected by this data collection is approximately 10 million people each financial year. As both Nadine and Steph have mentioned, there are things like single touch payroll and compliance requirements that evidence that this seamless transfer of data about individuals is happening in real time. And it means that both individuals and businesses must consider their ongoing compliance to ensure that they are not subject to administrative action as a result of the extensive sharing of data between the Department of Home Affairs and other agencies. And really, these considerations apply to all of those working or considering working in Australia, as well as those Australians working overseas. And on to the next slide. So from working in Australia to working around the world, back in 1997, it was predicted that with the introduction of Wi-Fi and portable computer technology, it would mean that workers would no longer be tethered to an office. And really, this technological revolution would allow people to indulge in what is the natural inclination to roam the globe. And increasingly, this work from anywhere option has become a reality for many. A recent American research study found that 10.9 million American workers currently describe themselves as digital nomads, an increase of 49% from 2019. Based on current predictions, by 2035, this number is expected to reach 1 billion people worldwide. Several countries are taking steps to introduce new visas to reflect remote work trends, and more countries are expected to follow suit over the coming years. Next slide. As of June 2022, more than 25 countries and territories have launched remote work or digital nomad visas that allow foreign nationals working independently or for an employer outside of their own country of passport to enter, stay and work remotely for a specified period of time. But as you can see, this represents but a tiny proportion of the world. And failing to address this remote work in immigration policies is ultimately a missed opportunity for governments. It is likely that many countries will take steps over the coming years to factor remote work into their immigration systems. But until then, individuals must ensure that they meet local immigration laws whenever they're travelling overseas and undertaking work, whether it be for local or overseas entities. The penalties can be significant, and visa compliance, even in third-party countries, may be considered when applying for visas in many countries. And on to the next slide, please. In addition to the individual compliance requirements of remote work, periods of prolonged remote work from another country can create significant challenges for employers. As discussed by Nadine and Steph, there are a myriad of challenges facing employers, which include the triggering of permanent establishment of the country overseas, as mentioned by Nadine, which requires the employer to pay corporate taxes and potentially comply with other regulations in that country. Payroll mandates require employers to set up in-country payroll for their remote workers or to explore and implement workarounds. Compliance with local employment and labour laws, including, for example, minimum wages, paid leave, workplace health and safety and discrimination, are also needing to be met. And these requirements are generally governed by the country in which the worker lives and may differ from where the employer is based, and as Steph has mentioned, may vary from even parts within a country. And the lack of awareness by employers and employees presents its own challenges. In addition, and as has already been outlined, an employee may be eligible for a range of worker protections, such as pension contributions and social insurance, that differ from those in the country where the employer is based. And then we come to the all-perennial issue of data privacy, which is a critical consideration. As we've recently seen here in Australia with the Optus data hack, there is always a risk of hacking and other data privacy risks. When working cross-border, there is an enhanced data protection risk for both the employer, the employee, and their clients. There is always the perennial desire to ensure that you meet immigration needs, and you have to find out what the appropriate visa to apply for is and what the relevant visa conditions are. Obtaining expert advice for each country is critical. We're very fortunate at BDO that we provide immigration services in over 97 countries, and this allows us to provide expert advice on a range of visa, tax and employment considerations across all major jurisdictions. And it's critically important that you get expert advice before embarking on any overseas work arrangements. Next slide. With the increased global movement of people and the changing nature of work, individuals and businesses need to prepare for working anywhere. Rethinking immigration systems for a new area of remote work presents both challenges and opportunities. For Australia, the focus remains on highly specialised skills and workers in critical industries, which will aid in Australia's economic growth. Businesses and individuals must be aware of the myriad of obligations they are required to meet to ensure compliance with relevant laws and regulations, both locally and in international locations. Ultimately, work from anywhere presents an opportunity for businesses to meet their staffing needs regardless of the geographical or demographical constraints, and for individuals to negotiate the work location that best suits their needs. As the war for talent continues across the globe, embracing work from anywhere arrangements will best position individuals and businesses to thrive in this new post-COVID world. Thank you very much.
Thank you very much, Rebecca. And also thank you to Steph and Nadine for their comments this morning. It's certainly a challenging time, not just for employees, but for employers as well. There were many concessions and approaches taken by revenue authorities during the COVID environment, which allowed employees to stay in jurisdictions perhaps longer because they were trapped. But now we're seeing a return to more normal, way rules apply in those circumstances. And unfortunately, because of the archaic nature of those rules, they're just not working in a post-COVID world. So it's certainly an area where we're hopeful that government will make changes going forward to make it easier and to allow the new normal, the new future to operate. We do have just a couple of minutes up our sleeve, so I might just touch on a couple of questions that came through during the session. And just starting with you, Rebecca, are we ever going to see, or are we close to seeing, a digital nomad visa in Australia at all?
I think at this stage it's unlikely, especially with the concessions that exist where you can sort of travel in and work for an overseas entity. But having said that, the department has announced, and part of the Jobs Summit is that there is a whole rethink of the immigration program. So who knows, watch this space over the coming months. We'll wait and see what happens.
Excellent. I will look forward to an influx of people onto the Great Barrier Reef and the like on their laptops. Another question that popped up was for Nadine. You mentioned that companies, should be looking at policies around remote workers. What are you seeing? Are companies developing detailed policies, or it's still being done on an ad hoc basis?
Yeah, that's a good question. So yeah, I think companies are actually starting to come to the party now. They are realizing that they are having more employees requesting to work remotely, so they are having to relook and refresh their global policies. And interestingly enough, we as BDO are actually currently updating our own policies to accommodate for that flexibility for its employees. But I would stress and caution that if you, for some companies, they actually don't have global policies, and if you don't have a global policy, I highly recommend that you at least assess each case on an ad hoc basis and on a case-by-case basis, and at least consider all your options up front.
Yeah, certainly being prepared, and rather than having a regulator come to you and tell you about where your employees are and what they're doing, to be prepared is certainly the key in that regard. Now, Steph, you don't escape either. So question for you. It's obviously really challenging to know where your employees are working, between New South Wales and Victoria and other sorts of states. Some companies are sort of taking the approach that, well, look, provided I pay somewhere, does that help me? Does it help mitigate risk if they're at least playing in one state for their workers?
That's a really good question, James, and thank you. So I think I'll answer it in the context of payroll tax initially, because so payroll tax, we know that each of the state jurisdictions, state government are very keen to collect revenue and ensure that they're getting the right amount of tax being paid. However, there's an interest and penalties revenue ruling in some of the jurisdictions. Off the top of my head, I think it's Victoria, New South Wales, and South Australia, I think, are the three. So it's not fully harmonised across Australia. But this particular revenue ruling contains a section on tax being paid in the incorrect jurisdiction. So let's say due to records not showing or not being able to accurately track where an employee is working, you disclose in Victoria, but technically wages should have been paid in New South Wales. Per this revenue ruling, the position in these jurisdictions where this revenue ruling applies is that provided you have disclosed the right amount of tax that's been paid by the due date, then there shouldn't be penalties and interest imposed as a result of those wages being disclosed in the incorrect jurisdiction. The situation will be different, however, if there's a higher amount of tax that should have been paid, and this would occur where the tax that should have been paid had a higher payroll tax rate. So that's the payroll tax position. In terms of work cover, there isn't a similar position that I'm aware of. Having said that, I mean, I think you'd want to ensure that remuneration is being disclosed somewhere, and I'm hoping, given the challenges with this space, we'll start to see some simplification by the regulators, providing some more practical measures so that employees are still covered, even where it's increasingly difficult to determine or to comply with these, I'd say, outdated provisions.
Yeah, well, hopefully some sensible results then, with at least in relation to penalties, recognising the challenges that employers often face in these circumstances. Well, we just clicked over 12 o'clock, so we'll probably end the questions there. Once again, I'd like to thank Rebecca and Stefanie and Nadine for their comments today. We're certainly hopeful you found that useful this morning. We certainly would appreciate sort of any comments or any feedback, and to flag the upcoming sessions in our Working in Australia series. The next one is payroll compliance, which is scheduled for the 16th of November. So we welcome you to that session, where we'll talk about all things around wage compliance, about compliance with a lot of other obligations, with single touch payroll, with super, and all the challenges that are presented in that space. We'll also have sessions as we close in on the FBT towards the middle of March in 2023, and also some year-end obligations, a reminder or refresher on that just post the end of financial year in 2023, which does seem a long way away. But once again, thank you very much, everyone, for your attendance today. We really appreciate it, and enjoy the rest of your day. Thank you.